Now turn to the third case on this morning's docket. That is case number 100529, State of Kansas v. Francis Everett.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Francis Everett. I would request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, you may remember this is a manufacture of methamphetamine case out of Smith County, and you may remember that the issues in this case in the Court of Appeals were pretty well set out by a two-judge majority and a vigorous dissent, and so I think the issues in a lot of ways are laid out better than I'm probably going to be able to. So I'm planning on spending my time talking about the first issue somewhat, although the court, of course, will lead me as necessary. The first issue in this case has to do with the trial judge holding that Mr. Everett had opened the door to some testimony, otherwise inadmissible testimony. And just by way of background, the facts in this case were that a snitch in this case accomplice had said that she had been involved with Mr. Everett in manufacturing methamphetamine in a rural part of Smith County. And as part of that testimony, she said when they got done, they smoked some methamphetamine, and in fact that Mr. Everett shot up some of that methamphetamine. That was a part of the snitch's testimony. Well, you'd like to be able to impeach the witness if you can, and lo and behold, it turns out Mr. Everett's on probation. And so unlike, I think, you and I, he actually has a record that he can look at of regular, frequent, and random drug tests. Except in order to get those in, of course, he has to call the probation officer. So there's this decision that's being made in this case. There's a motion in limine in place in this case saying that they shouldn't talk about any prior convictions or prior bad acts on Mr. Everett's part, and that's proper. But at some point, defense counsel in this case made a strategic decision that, look, it's very valuable to us to be able to rebut the snitch's testimony because we can show that he was clean at least at dozens of times during this time period that the state has alleged this manufacture took place. So they called the probation officer and said, were you his probation officer? Yes, I was. And in the process of being your probation officer, did you give him drug tests? Yes, I did. And how often did you give those drug tests? And the probation officer listed all the dates that they did those drug tests. And at any point, did any of those tests come up positive for methamphetamine? And the answer from the probation officer was no. At that point, the prosecutor said, well, we want to ask the probation officer then, why was he on probation? And defense counsel objected and said, I never asked anything about why Mr. Everett was on probation. I only asked about, was he on probation? And in the course of that probation, did he get drug tests, specifically methamphetamine tests? There were other tests given. Because it's in direct rebuttal to this witness who said, when they made this meth, that he smoked it and shot it up. But the district court in this case found that the door was completely opened to all sorts of testimony. And in fact, now on the question, why was Mr. Everett on probation? The answer was for possession of paraphernalia used to manufacture methamphetamine, very specifically. It is our claim, and I think the law supports the idea that we understand that a party can open the door to otherwise inadmissible evidence. And we did open the door to otherwise inadmissible evidence. There was a strategic decision made to call this probation officer, who otherwise would not have been allowed to testify. And generally speaking, I think as a tactical matter, you don't want any information about prior convictions or prior criminal acts. But there was a decision made that we're going to make a measured and specific questioning in this case about the part of the probation, and we are going to have to deal with the consequences of now the jury knowing that he was convicted even of a felony and was on probation.
Mr. Hodgkinson, can I interrupt you there? In Gunby, we made it pretty clear, I thought, that we were no longer allowing any type of 6455 evidence to be admitted absent 6455 protections. And I know Gunby's facts didn't involve an open the door, but there were some pretty strong statements that from this point forward, all bad acts evidence must come in through this statute. But you are not making any argument for us to go that way today, I take it, from what you just said.
I'm not making any argument
for us to say open the door does not apply if you're dealing with 6455 evidence.
I did not make that argument. If I understand your question right, that does Gunby preclude even opening the door?
Right.
I did not make that argument.
Okay.
So I'm skeptical that I can make that argument today. Maybe I will make it next time. Certainly the statute does not include, this court also looks at plain language of the statute pretty clearly, and that's where Gunby came from. And the statute does not have any exceptions for opening the door.
And I think when you read our case law on this open the door, it's pretty clear that the court in the past has said, we're setting it aside. This is a court-made exception.
Yeah, that's right. There's no provision for it in statute. But certainly the argument that I do have is even to the extent that you can open the door, just because you open the door some doesn't mean you've opened the door completely. There still should be a finding or some sort of relevance between the question asked by the prosecutor that now involves this extremely inadmissible evidence and the test.
You would agree that by necessity the door had been opened to the fact that Mr. Everett had committed a crime and was on probation is why he was being supervised. You're only saying the door wasn't open wide enough to allow the specific crime.
That's right. Absent us calling that probation officer, I think it would have been entirely inappropriate under the court's motion in limine to talk about any prior crime or him being on probation at all. So we did open, and that was a risk that was taken. The question here is, can we do that in order to elicit this very specific testimony regarding drug testing without getting into the specific details? The Court of Appeals majority, said they asked these vague questions. Well, yeah, that's what I guess if you call them vague. Actually, I think they were sort of specific in that it was specifically dealing with drug tests and not opening up this whole world of what was he convicted of.
Is it improper cross then once there's some evidence that he's taking drug tests that are being administered by a probation officer to ask why he was taking the drug tests? How far can you go with this? Are you just allowed to say, yeah, he was taking drug tests, he's clean? Could the prosecutor, in your mind, get into, well, it was a condition of probation? How far can he go as to why?
I think the test...
The purpose of the drug tests, yeah.
The test that's set out in the cases cited in the White, citing the James case, is sort of, what is it that would be unfair to the state? So to the extent that it's unfair to the state, that it is somehow allowing a party, the defendant in this case, to put on some evidence and present something in a way that's unfair if you don't allow the state to rebut, that would be the test. And so I'm trying to take your question and go,
right.
Is it ever relevant why they are taking that test? You're on probation, you're taking tests. Is it because it's a condition of probation or just a part of your treatment? I don't know. But I think we can fairly say that people might be taking drug tests and being in drug treatment for a lot of reasons other than being convicted of a drug crime, especially being convicted of possession of paraphernalia for manufacture of methamphetamine. That I think for any number of crimes.
I understand that point, but
and so that's the point.
I'm just wondering what kind of context can the prosecutor provide or try to frame or how far they can go in framing a context.
I think they have to show, here's how it's unfair for the defendant to put this evidence on and not allow us to rebut that. And there's no showing in this case. Why does the jury need to know that in this case, at least? And I still don't have an answer to that question. On the other hand, is the evidence damaging? Of course. It's, I suppose, as damning as you can have 6455 evidence be. That you have, in a manufacture case, a prior conviction for possession of paraphernalia for manufacture. It's not just in some unrelated crime or some minor crime or some collateral thing. It's about as similar as you can be. So the prejudice in this case is huge. The question, Your Honor, maybe the final answer to your question is, what's the probative value, and does it outweigh this prejudicial effect?
And that's typically an abuse of discretion standard that we apply to that weighing, isn't it?
To that weighing, yes.
And that's a pretty hard burden for you to overcome, isn't it?
It's I don't like that
Or
standard.
difficult.
It's a hard burden, and yet in this case, I think we make it because there is no showing of probative value.
Did the court do that weighing?
The court the court made a finding regarding whether it was the prejudicial value outweighed the probative value. But the problem here, and I think Chief Judge Green really sort of hit the nail on the head here when he said, what's the probative value? The district judge says, well, I think the jury might be curious about what this was. Well, so what? Juries might be curious about lots of things. You still have to show some connection between whatever this evidence is and some material fact, or in this case, when you're opening the door, somehow how it's unfair to allow the defendant to put this evidence on in the first place. And without some showing of something besides just curiosity of the jury, there's no probative value. So that's why I think we can meet this under any standard.
I think the Court of Appeals majorities found that you had waived an argument about knowledge by not having made that argument before them. So if we advance that that argument's been waived and that there's at least knowledge that's relevant, don't we have to start there?
Your Honor, the Court of Appeals finding on that matter has to do with the instructional issue,
Right.
which is a separate subsection of this. Certainly if the evidence is inadmissible for any purpose, then you don't even get to the instruction issue, I think, because I think there is prejudice. I don't think we have a difficult time showing prejudice in this case. We did not argue, and we sort of went through the district court's shotgun 6455 limiting instruction in this case. And we didn't attack knowledge. I always think these are difficult issues to argue in some respect because we're arguing that it's not admissible, and that's in fact our primary argument, that it's not admissible for any purpose. But if it is admissible for some purpose, then you have to give a limiting instruction. We didn't waive the issue of whether, we didn't concede that it was relevant for knowledge. Maybe that's what it's relevant for, if this court finds it's relevant for something. Or if, as the Court of Appeals majority said, maybe you should, if to the extent that you think it's important to allow the jury to know this, that you gave them an instruction saying it was relevant to allow you to understand why he was on probation or something like that. You have to give an answer. I mean, it's weird to think about saying, well, what we're really saying, Your Honor, is there should be a limiting instruction that says you shouldn't consider it at all for any purpose. Well, that's really that's the evidentiary question.
It's the defendant's knowledge that would have to be an issue. So was there ever anybody taking the position that he didn't even know what methamphetamine is, or he doesn't know what
No, Your Honor.
anhydrous is, or
No, Your Honor. I mean, I'm not today conceding that it was relevant for knowledge.
Okay.
They found we waived that with regard to whether the instruction was improper. Because to the extent that you find it's proper, you have to find it was properly admitted for some reason. And if you find it was, I do not concede that it was proper for knowledge. But if that's what the reason you found.
You're just saying we can't take whatever waiver was there and flip that waiver over into this issue as well.
That's right.
And I think that's a valid point.
And the only really point we're making is and the Court of Appeals agreed with this, that the instruction was overbroad. It was a shotgun approach. And the only question we have then is whether it was reversible.
And so do you think we have to reverse a long line of cases to get to where you want to be? I mean, the state cited several cases, and Papin in particular seemed to be one that was very difficult, I think, for you to distinguish. So what do we have to overrule those to get to where you're going with this issue? On Papin, the defendant took the stand and basically said, I'm on parole. And the court just this court didn't give that argument any credence at all and just very quickly dismissed it and said he opened the door and the state was allowed to get into the specifics of the conviction.
I don't think you have to overrule it. I don't think you have to overrule anything. I think this is just an application of the law as it is, that of course you can open the door, but just because I open the door somewhat does not mean that, when I testify and somebody then puts on rebuttal evidence, just because I testify doesn't mean that all rebuttal evidence is admissible. It's only in rebuttal to whatever I put on. That's not new law. I don't think you have to overturn anything to make that statement.
Any further questions of counsel? Thank you,
Your
counsel.
Honor.
Good morning. I'm Alan Shelton, Smith County Attorney, representing the plaintiff appellee in this case. I listened with interest to the argument here, and it appears that the only issue that the court is really concerned about in this case is this open the door issue. So unless I've thought wrongly, and you can let me know with your questions, I'll confine most of my argument to that. Taking it kind of in reverse order, you do have to overrule at least 40 cases, previous cases of this court and the Court of Appeals, to get to the point where you say that this did not open the door. Let's think about, and also think about, what prejudice was there to the defendant? Let's look what the jury already knew from the voir dire. I mean, this was interjected at the voir dire by defense counsel. They already knew that he'd been convicted of a drug crime, and he was on probation. They were told that by defense counsel. They put his probation officer on. Now,
Were they knew he was convicted of a drug crime? At that point?
at what point?
At voir dire, or really at any point until the states cross. They knew he was on probation, being supervised. They knew he was being
on probation.
tested.
Counsel,
I'm sorry.
if you let the justice finish her question, we'll give you a chance to finish your answer without interruption.
What I understood is that they knew that he was on community corrections supervision, that he was being tested on a regular basis for the use of methamphetamine, and that he was there because it was a felony, and that everybody that's under community corrections has committed a felony. But I did not understand that they had been told that he was convicted of a drug felony.
Well, Your Honor, if you're a juror in that case and you're told by his probation officer that he was required to participate in a meth treatment program, is it some great leap of logic to figure out that his crime had something to do with methamphetamine, or at least drugs?
I don't know. My experience as a district court judge, where a lot of people were put in drug treatment programs, even though their underlying conviction was not necessarily for that specific addiction issue. They may have done a robbery, but drug treatment was required. I don't know why a jury would necessarily have to assume otherwise.
Well, maybe because they weren't ever a district judge, and they don't know that people that don't have a meth problem are required to participate in a meth treatment program. I never do that until you just said that. I always assumed that people that were in a meth drug treatment program had a problem with meth.
Well, they may have a problem with meth.
Yeah.
That may have caused them to go to do the robbery. There may have been a causal connection, but that doesn't mean the conviction was for that. Anyway, I don't mean to get hung up on that, but
given that argument, what was the probative value of the specific crime? If you're saying that the jury already knew or could reasonably infer that he had committed a drug crime and was in treatment for meth use, what did the fact that he was convicted of possession of paraphernalia with intent to manufacture meth add to the mix?
Well, let me answer in this fashion. Until, at least at the time this brief was written in this case, this court has said at least 30 to 40 times that the defendant may open the door to otherwise inadmissible evidence. That's been the statement of the rule up until this time. Now, if you're going to change that, that's okay.
You read that to mean also irrelevant evidence, that it can be irrelevant and the I mean,
I think
we have
I think it's
inadmissible.
highly relevant, don't
Well,
you?
but
I think it's highly relevant for a juror to know.
That was my
this-
question.
Yeah.
What was the specific relevance of the specific crime if they already knew that he had been convicted and was on probation or community corrections for a drug crime?
A, they weren't left to speculate about what kind of meth crime he was involved in. It could have been worse. They could have thought he had been convicted of manufacturing. They could have thought he was guilty of dealing drugs, methamphetamine. They could have thought any number of things. But the rule has always been that when the door is opened by the defendant, the state has the right to come in and fully explain the transaction, so the jurors know exactly what was involved. Now, personally, I'm not going to be a county attorney again. So if you want to put a rule that we're no longer going to have an open door rule unless it meets relevant standards, then you're going to have to overrule a whole lot of cases, because that's never been the law in the state. There's never been a relevancy standard applied to it until now, I guess. So
there
as far as the
there would
limiting
be,
instructions,
as far as you're concerned, then, once the door's been opened, anything would be admissible.
anything
Because-
associated with that transaction, of course, I couldn't ask him questions totally unrelated to his conviction. But all that I asked was, what was the crime for which he was convicted? That was it. Everything else had been told to the jury by the defendant.
Well, no, not the crime of conviction. And then how far can you go with that? Would that allowed you then to making the same argument, the facts underlying the prior conviction?
There's Kansas cases where that was done, Your Honor.
And in your mind, that would have been okay once the doors opened. Basically, anything underlying the probation in which he's testifying to would be open.
The only thing I'm telling Your Honor is that prior to now, perhaps, no Kansas court looking at this, other than an unpublished opinion, has ever said that the evidence has to be relevant. It does have to be limited to the transaction or the subject to which it was referred to. It can't be just about, now that opens up the question about where were you, on August 5th,
But anything
and so
related
forth.
to the prior crime in which he's on probation for would be admissible.
I'm sorry, I didn't hear you.
Anything related to the underlying facts, circumstances of the prior crime that led to the conviction would be admissible.
Yeah, within reason. And you're going to remember, all he was asked.
Oh, I understand you didn't go that far, but you
No.
could go that far.
No, I think so. And I think if you look at the case laws, there's a case in there where a witness mentioned that a statement had been given by somebody else, and then when on cross-examination or redirect, the county attorney was allowed to introduce the whole statement, even though nothing contained in the statement had been included in that cross-examination of the defendant. So, I don't see the issue here unless you're going to make a new rule. And if you're going to make a new rule, fine, make a new rule.
No, it's trouble. Justice Lukert's scenario happens all the time where there's a robbery. The robbery is associated with the addiction, and so there's treatment. And so you could get into the facts of the robbery, even though it's entirely unrelated to the current prosecution in terms of what you're trying to prove. You could get into the facts and talk about how he held a gun to someone's head. I mean, how far could you go with that?
Well, I'm not. I keep coming back to fact.
I mean, I know you didn't, but you're saying that anything related is relevant to that inquiry.
prior
If you open
Kansas-
the door to a probation.
Prior Kansas cases, it is said the state is free to enter and explore fully. This court has been extremely liberal with allowing the state, once the defendant puts information that could not otherwise, I couldn't have called the probation officer and asked him all this stuff.
I understand.
And they made a strategic trial decision. Frankly, in her position, defense counsel position, I would have made the same decision. I would have taken the same risk. Because I thought the evidence that he didn't fail any of these meth tests was very good evidence for the defendant. Very strong evidence. I would have taken the chance, but I wouldn't have thought I could have my cake and eat it too. As far as a limiting instruction, please look at the brief in here and look at the record in this case. There was no request for a limiting instruction by the defendant in this case. None. The position defense counsel took was no limiting instruction should be given. The judge went ahead on his own and said, well, I think it could apply in these matters, and went through a list of them. He then asked defense counsel and me whether that list should be restricted further. The defendant did not respond. She did not ask that the list be reduced. She didn't want the limiting instruction given at all. Now, talk about invited error. Now they're saying, well, they gave the wrong limiting instruction. I don't know how a defendant can do that when they didn't request a limiting instruction, and when the subject was raised, object to the court giving one. And it certainly is relevant as to knowledge. If you're in possession of methamphetamine tools with the intent to manufacture, it certainly goes to showing that you have knowledge of the process. And that was part of what was being testified to here was the witness testified as to how they manufactured this methamphetamine. So it certainly was relevant to knowledge. I'm not going to expend all the rest of my time unless you have further questions about.
Counsel, refresh my recollection. What was the specific prior conviction for?
It was a prior conviction was for possession of drug paraphernalia with intent to manufacture methamphetamine.
And that, in your view, would be relevant to the issue of knowledge to manufacture it?
Yes, that's how to manufacture. You possess the tools. I think that's very relevant. If you really went at exploring into this thing, originally he was charged with manufacturing. This was a plea down. But that's the way the system works, and we know that. But he was only convicted of possession of drug paraphernalia with the intent to manufacture methamphetamine, which allowed him to get into this meth treatment program.
Did the defendant testify in this case?
I'm sorry?
Did the defendant testify in this
No.
case?
No. Elected not to.
Why did the state delay amending the complaint?
When did we do?
Why did when the witness opened it up to May? Why wasn't the amendment made at the conclusion of the state's case, at least, if not before?
Well, I suppose that's my fault. It came up actually at preliminary hearing that it could be later than April. So I'm arguing that as there was no surprise to the defendant that it was done, and I think the trial judge handled it masterfully. There was no prejudice to the defendant because we stipulated that he didn't miss any days of work during that month, and he didn't fail any meth tests during that month. Didn't fail any drug tests, period, during that month. So, I don't see that there was any harm to the defendant.
You think that stipulation has the same persuasive value as if the defendant had been able to have the witnesses testify to that?
Oh, certainly. Certainly I do. I'm not going to concede that Smith County jurors are ignorant and can't read. The stipulation's stronger than that because they have it in writing right in front of them. No need to reread the testimony on that issue. They know that was conceded by the state.
Any further questions of counsel? Any further presentation?
No, thank you, Your Honor.
Thank you, counsel.
Your Honor, I just want to clarify one point on the record regarding what the jury knew before this. This is record volume 6, page 48, and this is where the defense attorney in this case, Ed Waudier, talked about. And she says, and I quote, "When you are sitting as a juror in this case, you'll hear that Francis Everett was on community corrections. Is that something that if you heard, is that automatically going to make you think that in this particular situation, he's been in trouble before, he's got to be guilty of this. There's no mention of the crime at that point. And in fact, at the next sidebar, the district court, I think, started questioning what's going on here. We had a motion in limine saying you're not supposed to be talking about prior crimes, and now you're talking about probation here. And this is at page 60. The defense counsel says, I want to make it clear I will be calling the community corrections officer not to put before the jury the actual offense, but because the community corrections officer has vital information testimony pertinent to this case. He's making it clear. And in response at page 61, my colleague says, well, all I can say, Your Honor, is it will depend on what the officer says as to whether or not the nature of the prior offense may be relevant or not. I think that's all we're saying. Thank you, Your Honor.
Counsel,
And Justice,
we have
I
counsel.
apologize if I may have misspoke earlier about voir dire, what being mentioned in voir dire. I apologize for that. It's been 4 years.
Mr. Hodgkinson, I think Justice Lukert has a question for you if you'd come back to the lectern.
Did you have one?
No, I was
Okay, I'm sorry.
interceding.
Could you address the standard of review issue on the instruction and also specifically tell us what your relief is that you request on that? I mean, in terms of, that's not the right way to ask that, but, whether the instruction should have been given at all or whether it should have been paired or, respond to that.
Sure, Your Honor. The claim we're making, we don't think the instruction should have been given. I'm consistent with trial attorney here. Trial attorney says, look, we don't think this evidence, the extra evidence should have come in at all, and therefore we don't need any instruction. But to the extent that we're going to give an instruction, it certainly, this court has said, should be tailored to whatever the relevant purpose of that evidence is, whatever you find that to be in this case, even if it's simply to satisfy the jury's curiosity. That's what you should tell the jury. This is what you can use it for, not as propensity evidence. That's why we have 6455. And so the standard review on giving the instruction, we didn't object to the list. I agree with that. Specifically, we did object to the instruction in general, and whether that has any effect, I guess the court will tell us. But as far as the remedy we're seeking a new trial where, to the extent that you find that this evidence was properly presented for some purpose, that the jury's told you should only consider it for that purpose, as opposed to, we don't even have a silent record in this case. We have some positive information that they did consider it as propensity evidence.
Okay, I just want to make sure I understand, given that the evidence came in, is it your position that an instruction should have been given, but it should have just been phrased as, you can consider it to understand why he was on probation, but for no other reason?
Yeah, something like that. And in fact, when I'm reviewing the voir dire and the colloquy that they're having between court and counsel at that point, judge says, I'm going to give a limiting instruction. And she said at that point, that's okay, that a limiting instruction of some sort is given, because I, defense counsel, have now brought in some prior bad act evidence, I suppose. So maybe that's appropriate in some way. Our concern, our claim is that the shotgun approach taken by the judge's limiting instruction didn't have any particular effect. And we even have some evidence of that in this case.
Any further questions?
Thank you, Your Honor.
Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.